I
So on redirect, Prosecutor McClellan asked Lieutenant Holeman another reason that the sticks were on the girls was something called an undoing.
The prosecutor introduced that.
The prosecutor on redirect, a completely new theory about the psychology or the psychological significance of the sticks.
And Judge Gull ruled, as most of you know, that it didn't open the door.
And that is exactly what we're going to be analyzing today. Welcome to Defense Diaries. I'm your host, Bob Motta, and this is our continuing coverage of the people of the state of Indiana versus Richard Allen. And I am joined by my beautiful and brilliant co-host, Ali. What is up, girl?
Hey, babe. Hey, all.
So today we are going to be looking through a few things. I believe we're going to be starting with the transcript. And then we're going to be getting into the motions that cover the issues that we're going to be covering in the transcript. So we wanted to give you the context first so that you understood what the motions were pertaining to.
Yep, this is about those two mid-trial motions in Lemonade that the defense filed. The ones arguing that the prosecution opened the door to evidence that Judge Gull had already excluded.
Right. And I mean, ultimately, hold on. Did you send me the motions or do we have them? Do we have them up? Are you going to be putting them up?
I can put them up.
Okay. Right. So ultimately, hold on. I'm trying to get them to my other screen. So here's the thing. We're going to let the transcripts speak for themselves. We're going to read directly from them. We're not going to do quite a dramatic reading. I'm not going to wear the hat for the transcripts, but we will show you exactly what was said and who said it and when. And then we'll read both motions word for word. And then we're going to analyze whether or not Judge Gull was correct.
Right. So we're going to so for those of you who don't know, the victims, Abby Williams and Libby German, were found with sticks and branches arranged on the body. The state's theory was that the killer used the sticks to conceal or camouflage the bodies. But the defense, on the other hand, wanted to present evidence, including an expert, that it was ritualistic. And so that's the testimony we're going to be focusing on that's going to lead into the motions. However, my computer has now frozen.
Is it really?
Well, I got all these. I'm about to force quit the Acrobat and relaunch it.
Wow. So are you going to dip from the live?
No, I just did. So hopefully when I open it back up.
Okay.
So you should have two files babe, open on your computer and store it in the Richard Allen transcripts folder on your computer. One that says Ole, is that his name? Ole? And one that says Holeman.
Okay.
So we're going to start with Ole because that's what happened first. And we're
Okay.
just going to read the relevant portions of the testimony. And I gave you a list of the relevant portions.
Okay.
Please wait a few minutes while update is installed. Tech wizardry.
There it
Oh my
is.
god.
There it
I had
is.
too many Acrobat files open.
Yeah, and you had my computer, so like I didn't get anything set up ahead of time. So I'm sitting here struggling trying to get this thing over to my main screen. And of course, I'm still stuck in the wrong Dropbox. So
No, they're open already. So can't you just drag them over?
open where? In what kind of document? Like,
On
is
your
it a Word?
PDFs. I also saved them on your computer under the
Oh,
Richard Allen transcripts folder. Not in Dropbox, on your actual computer.
oh, okay.
Oh. Okay, it opened back up.
Let's see if
No,
I
it
can
didn't.
find it. I'll see if I can find it. Richard, it's a weird place to store it. Richard Allen transcript.
Well, that's where we already had the transcript, so that's why, my gosh. It's
Yeah,
just messing with me.
I'm not seeing it, dude, at all. I don't even know. Like I
You
put
don't
it in,
so
I
you
put it
don't
in the
see
spotlight, and I don't see any folder.
okay, so click on your Finder window, and then type in Richard Allen. Search by name. Files with this name.
Seems like it should have popped up in Spotlight, but I don't know. Okay. All right. I almost feel like we should restart the live because this sucks.
Mm.
Yeah, you gotta make sure I have my computer before 2 minutes before the live starts. Yeah.
Well, you know.
Yeah, I mean, it happens. All right. Richard Allen. Okay, there we go. All right.
So at the bottom, there's one that actually says their names, and
Well,
so
there's okay, so yeah, there's the first one and then the second one. Which one do you want me to open?
we're starting with it says Ole testimony.
Okay. So there's Oli testimony and there's pages from Oli testimony.
Yeah, just it doesn't matter, but I would just open the Ole testimony
Okay.
because the pages are going by the transcript themselves. We start at 192.
Okay.
And you should have something that says, ay, ay, ay.
All right.
All right. So just by way of further background, the defense wanted to present evidence, including expert testimony from Dr. Dawn Perlmutter, who testified at a pretrial hearing that the stick arrangement had ritualistic significance related to Odinism. So again, Judge Gohl excluded that before trial. So going into trial, the jury was never supposed to hear anything about ritualistic significance or Odinism. The question that we're presented with today is, did the state's own witnesses open the door to allow that in? And that's going to have us getting into the testimony. So we're going to start with Brian Ole, who they treat sort of like a CSI, crime scene investigator, because he was helping with that, but he's a conservation officer. He testified on October 22nd, 2024. And again, we're going to read several sections from his testimony.
Okay, so who are the players, babe?
So we've got, let me see, we're in 192. Sorry. So I'm going to play the lawyer and you're always going to play Ole. So
Okay.
he All right. So I'm going to start at line 21. You good with that?
Sure.
I'm going to ask you to remain there, and we're going to move to the photographs that you took documenting portions of Ground Zero. States Exhibit 90. What do you see there?
This is a photograph of the area, roughly a portion of the area, which you refer to as Ground Zero. These are the bodies of the two deceased individuals, the two victims. This is the body of AW and the body of LG. They are a few feet from each other, almost in a perpendicular way, with their feet closer to each other than their heads. So this is also a depiction of what I would say the area looked like with deadfall and with leaves and debris and twigs, sticks, branches, and the area, as it appears in most of the area around where the bodies were located and the area around or along the creek and around the floodplain and the river bottom.
There's a discolored area just as we're looking at the photograph, to the left of AW's, I'll just say Abby's, shoe. What was that?
That's an area of blood, a pool of blood.
Photograph States Exhibit 91. Is that the foreground? What's that?
This is the area in the previous photograph of blood found on the ground and over the leaves and sticks in the area. The previous photograph would have been taken from over in here, indicates, and the girls are kind of laying next to each other, closer at the feet and farther at the head.
Did you observe any blood on the feet, the bare feet of Libby?
Yes, and I think there's actually a little bit visible right here on the feet.
And which
Indicates.
portion of the
I'd call that the heel of the right foot.
and did you notice any blood anywhere else on her? On the right leg?
Yeah, there's several areas of blood on her thigh.
I'm talking about the lower part of the leg.
Yeah, later this picture, nothing is depicted, but there is other areas of blood on the lower leg, particularly on the back of the leg. There are some areas.
Photograph 92, is that?
So this is the previously discussed area or pool of blood. This is the right foot that was previous in the last picture. Then there is areas of blood on the thigh, the hand, up on the arm, on the torso, at the neck, and again on the left arm, which is extended above the head. Areas of blood throughout the body and in between the thighs and the area on the thighs.
You took close-up photographs of both victims, is that correct?
Yes.
And what was the purpose of that?
To document the scene and to document the items that we found at the scene, to give information later to potential analysis to anyone analyzing anything else that was found at the scene.
This photograph of Libby's body, is this what you saw when you were standing over her?
This is, and this is also, there were limbs and branches that were placed over the bodies. One actually went through here, and you can see it appears that the limb actually transferred some debris and some decay into the armpit area. You can see a large area of blood, movement of blood, the incised wounds or wounds caused by what I would refer to as a sharp instrument or sharp-edged instrument, blood movement up, away from the injury and moving up the face and into the area of the eye and the nose.
Photograph 94. It's another from looking at the top of the head down.
Again, this is
the gaping wound, is that essentially covered by a stick or branch?
Several of the injuries were covered, yes. Was it fully covered or completely enveloping? I would say no, but obscuring would be a term that I would use to describe it. Yeah, again, it's a very similar photograph to the last one taken from a different angle.
The process of the two victims here, did you choose to begin with one in terms of the specific concentration and then move on to the other, or did you do both at the same time?
No, you can't be in two spots at once, and we concentrated our efforts first upon Libby and documenting her body and removing her body, and then moved over to Abby's body and documenting it and removal of that body.
Sergeant Olehay, you had 3 crime scene investigators and Jim Cody, a fourth, for a portion of this. You could have had 2 on to process each victim. Is that correct? At the same time or simultaneously?
It's plausible, but it's not what I would consider to be the best option.
All right, so now we are going to move to the cross examination. So, what is important from what we just read is they brought up the sticks. He talked about the sticks covering the bodies, um, and introduced that there were limbs and branches that were placed over the body, and also said that they transferred some debris and some decay into the armpit area. So that is where sticks sort of come up. So now we move as defense attorney Andrew Baldwin cross-examines Olehay, zeroing in on the word placed because it's um, implied by this. So we're going to start at volume 11, page 245, line 1. For those of you that have the transcript. And
245 line 1. Okay. I think Brad did this cross
oh,
because it says on 244, volume 11, page 244, Rosie said he'll rephrase the question. And I think Luttrell did did the direct. Okay.
all right, let me.
So you want me to start with
No,
line
because
1?
I'm gonna ask you a question first, right?
Yep. Mm-hmm.
Give me a second. Sorry. Okay. Okay, so actually we're gonna start on 244, line 2. All right. Now, in terms of that, the crime scene in general, would you agree with me that when you got to the scene and first observed the scene, that there were some unique characteristics associated with the scene?
To which I would object to the form of the question, Your Honor. The quote, "Would you agree with me?" suggests he's offering his own opinion to the jury, so I'd object to the form.
I'll rephrase the question.
Court sustained.
Were there some unique circumstances associated with the scene when you got there?
I would say every scene presents its own unique circumstances.
Okay. What about that scene?
As with all scenes, this one presented unique circumstances.
One girl was naked, right?
This scene, yes,
The other was dressed, right?
that's correct.
And those girls were lying on the ground and there were sticks laying on their bodies, were there not?
There were.
And did it seem apparent to you that those sticks were not there coincidentally, that there was something that was intentionally placed there?
They appeared to have been placed there by an individual.
And did you place any significance in that aspect of the scene?
That it appeared to be an attempt at concealment. That was what I assumed.
Okay, that was an assumption.
That was a presumption.
At any point, did you ever make the assumption that maybe there was some attempt to communicate something by those sticks?
No,
Even as you sit here today, that thought's never crossed your mind?
I don't see any significance in the position of the sticks. They appear to me to be positioned to conceal, in some way, the fruits of the crime.
Well, there's very little parts of those bodies were concealed, right? We can see that in the photo, right?
Yeah, I mean, there were not, they were not completely covered.
And did you find one of those sticks to have an artificial or I guess a man-made cut on it?
There may have been items. No, I didn't find anything that had a man made cut to it as I would define a cut.
Did you end up collecting those sticks on that day? March 14th? It says he said the date wrong.
Yeah, I did not.
Okay, you waited to collect those sticks until a few days later, is that right?
They were collected later.
And that was outside the normal course of the investigation that you would collect sticks days later?
It was.
Somebody suggested to you to go back and collect those sticks, right?
They did.
And in fact, there were a couple of occasions when you went back and collected some sticks. Is that right?
I did not know.
Do you remember a conservation officer suggesting that happen?
No,
You acknowledge that, well, strike that. Are you aware of the original source of any clothing that was found on Abby at the scene? In other words, whose clothing that was determined to be at any point?
I don't know what a determination officially was. The items appeared to be one of the items had the name German on it, identifying it. I make the assumption that it belonged to Libby or a member of Libby's family due to the name being on the back of it. And then the sizing of the clothing was more consistent with the size of Libby than it was Abby. Some of the clothing appeared to be too large for Abby. The jeans and the sweatshirt appeared
So, a lot of these
to be other items.
I'm sorry, go ahead. You may finish. I didn't mean to interrupt you.
They just appeared to be other items not normally worn by Abby.
Okay, so the logical assumption to be drawn there is that Libby was disrobed at some point, and then those clothes ended up on Abby. Is that right?
That would be the logical assumption.
Were you able to make any assumption about the chronology of that happening?
That would lead to a large amount of speculation of items that I don't have at hand.
And were you able to make any assumption about the location where that occurred?
I was not.
Whether it was on the south side of the creek, on the north side of the creek, or somewhere else?
I'm not able to determine where and when those events occurred based on the evidence at the crime scene.
Were you able to determine where any of those sticks came from at the scene?
They were one of the largest pieces. There was an indentation that it appeared that the stick had been moved from nearby the body, but that's just an assumption. And I'm in no position as an expert to determine the movement of items.
Did you do any testing with regard to those sticks to determine what type of tree they came from or what their source was?
No,
There were shoe impressions found at various areas around ground zero and even on the other side of the creek. Is that right?
I believe there were some found, yes.
Okay, and some of those were along the bank of Deer Creek.
I believe so, yes.
And is it fair to say that there were signs that there had been foot traffic in the area prior to your arrival on that day?
Yes, I was aware of a very large search the day of prior to my arrival, but multiple searchers and a search by family and friends the previous night in the general area.
Thank you. One of the things that can compromise the integrity of a crime scene, right? People having been walking around it.
That's correct.
And was there ever any determination by you to discern where any of those impressions came from?
Not by me.
We heard testimony earlier that, hey, it was maybe, I think it was Mr. Datzman testified that, there was one shoe impression that was found that maybe had some similarities to one of the shoes that was recovered. Are you familiar with that at all?
I'm not.
Okay, so in terms of any of those impressions, did you find any impressions from somebody who was wearing smaller sized shoe? Maybe, something the size of the girls?
Not that I'm aware of.
Okay. Was there any effort to really do anything with those shoe impressions from to try and learn from those impressions?
I'm not aware of a specific effort to try to identify specifically to the shoes. The shoes had distinct and different characteristics to their soles. I was not privy to the specifics of any of the impressions taken. I know photographs were taken of shoe impressions, but that's the extent of my knowledge.
Okay, so you can't really draw any conclusion about those shoe impressions other than the fact that they exist, right?
I know that there were impressions found near the area.
Okay, so now we are going to move to volume 12, page 1, line 1. And so the prosecutor isn't done. On redirect, he brings it back again, asking whether those branches look like they had been arranged. Then Baldwin steps up one last time to lock in that Olehay isn't giving expert opinion. So we're going to start there.
Where was it? I'm sorry.
Volume 12, page 1.
Okay.
Hold on, I'm not there.
So I think you actually start volume
Yep,
11, right?
yep. Did you make any attempt to try and preserve that part of the tree? Maybe take a chainsaw or cut that part of the tree, preserve it, anything like that? Wait, I'm
Uh,
sorry.
no, it was documented and preserved with photography.
So you didn't preserve the item itself like you did the sticks laying on the ground.
No,
Okay. Are you aware that there was a blood spatter expert hired in this case just this year to take a look at that tree?
I'm aware that an expert was contacted, but that's the extent of my information.
Where blood spatter experts available to you in the course of your line of employment back in 2017?
I believe so. Yes.
Okay. And did you employ one or recommend to anyone that one be employed?
In this case, yeah, to meet the definition of the Indiana State Police Lab's manual for an expert on that matter, no. To have someone trained at the scene to examine it, I would say yes. Sergeant Page had been trained, but he's not a qualified expert as to the lab manual's definition of an expert.
Okay, so after you cleared the scene, did you employ a blood spatter expert to assist you in this case?
Objection, Luttrell, asked and answered. The court sustained.
Is it possible that a blood spatter expert could have assisted in helping determine the chronology of events that occurred out there in terms of when the girls were disrobed and clothed again?
I'm not aware of a technique in blood spatter that would have given that information.
Sorry, I'm trying to find where the redirect starts.
Are we done with that section?
Yeah, I think that it went. Sorry, I think that I um gave us the wrong. I mean, that ends that little part, and it.
Mhm.
So I'm trying to find the next. Okay.
Doing great, babe. Doing great. Is it in the same transcript? This
Yeah,
the same one?
yeah. Okay, so
Did you say you're looking for the redirect?
I'm trying to find where.
That starts on 31 of 32, so I don't.
Okay, I think I know where it is.
Alright, well, you just let me know when you find it. It's no moving on. Gotta find it. Patience, it's a virtue. It's not that bad. It's, like, kinda typical for us, isn't it? Do you wanna switch to the motions since you've lost this?
No,
So
give me 1 second.
alright, let me see here.
Alright, so I think that I think that might have
All right, what are you doing, dude?
I
This is
just
like a
don't
crazy long pause, bro. We can't like,
alright,
come on, man. Like, move on. Let's go. I agree. Now I agree. It's time to move on. We're sitting for 5 minutes in silence. Let's go.
alright.
Come on.
Okay.
I feel like you're saying okay just to placate me for like another
No. I
second.
alright.
Is that for another 30 seconds? The all right? Is that like when I hit you up, like when you're coming from somewhere, you're like, oh yeah, I'm at exit Naperville Road, and you're really like 10 miles away from that. Just to buy time.
Yeah.
Feels like that. I mean, what are you looking
Alright,
for?
so I
I
was
can
trying to
help.
find that the question on redirect that I had that I don't see now.
Okay, well, I mean, we'll have to work around it. We can't sit here for half an hour looking for it, right?
Okay.
Yeah.
Yeah. Alright, so do you wanna go to Holman's testimony?
Yeah, I mean, I'm following your lead here. So you
Alright,
just tell me
so,
what's up.
later in the trial, Jerry Holman testifies, um, and that same issue comes up about the sticks, and there's a dramatic sidebar, so we're gonna get into that as well. Um, and it first came up in the cross. So we're gonna start with Baldwin's questioning, I think it's Baldwin, of Holman about the bloody sticks that were left behind.
Okay. And so is that volume 15, page 115?
Yeah, it's
Okay.
it's labeled as Holman.
Yeah, there's a couple, but
It's just Holman.
okay. No, I mean there's two Holmans in there. But it's volume 15, right?
Yeah.
Okay. So yeah, it's McClellan and Baldwin.
Alright.
But I don't know what page you want me to start on.
We're at, uh I think 136, line 90. Let me is that what you have?
Mine starts at 136, page 90. No, I was at 108 when it opened up, but
Okay, so we're gonna start at 136,
okay.
just to give a little background.
Okay.
Oh, I said 136, page line 90. Oh my gosh. Okay, so bloody sticks were left behind at the crime scene and collected a number of days later. You heard that testimony?
I'm not with you. Like it doesn't
Sorry.
go up to line 90. It
Yeah,
goes
line 21.
Where'd you come up with line 90? All right.
Reading my
I did.
notes.
I did.
That's a mistake?
No, it's not a mistake. I don't think it's a mistake.
So it's acceptable to leave bloody sticks behind rather than gather them as evidence?
I think they tested them and observed them, as you've heard testimony, and they decided to leave them there. And then when DNR saw them, they thought, and that's why we went and got them.
You were in the courtroom when Chris Cecil testified, weren't you?
Yes.
And he made several mistakes that he noted, including transposing 2 digits on the screen. You remember that?
He did make mistakes.
You know, if Dan Doolin transposed any digits when he typed in from his notes and put it in the computer,
I do not know that.
there's been mistakes made in this case, hasn't there?
There's been mistakes made, yes.
May I approach, Your Honor?
Sidebar conference conducted.
Okay. I didn't know if I'm sorry to do this. I just don't know if that was objectionable. You can read it or a violation of the
I don't know how that, definitely not this one, because you're opening the door. You can ask an audible, this is part of the motion in limine, your motion in limine.
right.
Well, that would be opening. I think you opened the door with Olehay or Olehay. But my objection to you is you can't open the door and then say, okay, well, all this stuff comes in. And I get it that you're trying to elicit through him. He's going to say yes. He was trying to hide it. But my issues is that you're using it later to try to get this stuff in because you said the door was opened.
The court. I mean, is that his belief?
Are you?
Yes. The court. There's no pattern.
McClellan, right.
The court. On the evidence found there.
McClellan, right.
The court. So these are fine. I would say stay away from C, as this kind of implies, Mr. Baldwin. I apologize for having to do that. I just wanted to clarify.
The court, no, it's fine. Sidebar conference concluded. The court, you may proceed.
Thank you, Judge. I want to talk to you about the sticks on the girls.
Okay.
You believe that the killer was just trying to cover the girls to conceal the bodies so no one would see them?
Camouflage, yes.
Camouflage. You don't believe there's a pattern on Abby at all?
No.
It's random.
Yes.
And the killer, therefore, you must believe, took the time to lay one stick on Abby and another stick on Abby and a third stick on Abby.
Correct.
You don't believe that bodies were posed or positioned?
No, I don't.
There's no fingerprints at the scene of anybody?
No.
Libby's hands had blood on them, but Abby's hands had no blood on them. Is that correct?
Correct.
All right. So this is what that was the extent of the cross-examination that focused on them claiming that this was camouflaged or just placed them. So then we're going to get to the redirect, okay? And what the state then gets, redirect, and then what the state gets in this regard. So it's page 140.
Okay. Is that in the other one? This one only goes up to, oh wait, page 140, never mind. So that's going backwards, right?
No, didn't I just read from 130?
Volume, that's cross-examination, babe. For volume 15 at least.
Oh. Okay, so let's start on page 148.
Okay, which volume?
It's the same volume. It's the same. We're in the redirect.
Okay. All right. It's okay.
Okay. The sticks on the bodies, you believe they were there as camouflage or to hide the bodies? Is that correct?
That is my belief.
You also had information they may have been there for an undoing. Is that correct?
That is correct.
And that right there is the full extent of it. That was never anything that the defense mentioned. The state introduced a whole new thing. They started with just this camouflage thing, and then Defense talked about the camouflage thing, and then they introduced this undoing.
Right. Meaning it had never been mentioned by the defense at any point. That term specifically, the undoing, which,
Right.
as Ali was talking about earlier, and we've actually had Dr. Perlmutter on our channel here for an interview, which is very interesting, and I highly recommend everybody go back and watch that. But I mean that is the type of wording. It's right in line with exactly what her testimony would have been about had she been allowed to testify at trial.
All right. So then also, one of the jurors asked a question of Holman again about the camouflage, and was it meant as natural debris or deliberate placement? So it was something the jurors picked up on and, still didn't get a full answer for. So now let's go to the motions. There were two motions filed, and I will pull them up.
Okay.
Sorry, guys, my notes on the transcript, but we've got the relevant portions because that pretty much covers how it really the aspects that were important. And I will share this motion. All right. So this is the motion to admit evidence of Odinism, Norse paganism, ritualistic killing. Comes now the accused, Richard Allen, by and through his counsel, and moves this court to admit certain evidence that this court thus far has prevented the defense from presenting to the jury, pursuant to its September 4th, 2024 order. In support of said motion, the defense states as following. On Tuesday, October 22nd of 2024, CSI Brian Oley, or Olehay,
Olehay. I would say Olehay, because I think
okay,
it's spelled. I don't know if Andy misspelled or if they misspelled it in the transcript.
testified concerning various aspects of the crime scene. During his testimony, CSI Olehay indicated that the sticks covering the girls was an attempt by the killer to conceal the girl's body. On September 18th, 2023, the defense filed its first Franks memorandum in which the defense laid out in painstaking detail the various pieces of evidence that provide support for the theory that the crime scene contains various signatures related to Odinism slash Norse paganism. On August 1st, 2024, the defense provided the testimony of Dawn Perlmutter to the court. And again, for you guys out there, this was a pretrial. Dr. Perlmutter provided her CV and testimony at said hearing. Dr. Perlmutter experience included, among other things, training the FBI and other local, state, and federal law enforcement agencies concerning how to identify a ritualistic crime scene, and literally writing the book on ritualistic crime scene identification used by local, state, and federal law enforcement. After reviewing the crime scene photographs and other reports and documentation, Dr. Perlmutter's testimony included her assessment that the sticks on the bodies, F tree, and other aspects of the crime scene were textbook signs of ritualistic murder related to Odinism slash Norse paganism, including using sticks and blood on the tree to form runes and bind runes. Dr. Perlmutter's belief did not come out of left field as law enforcement began investigating the Odinism, Norse paganism angle as early as 2 days after the girls were found, and law enforcement continued investigating the Odin, Norse paganism angle until the death of law enforcement officer Greg Ferenczi in 2021. The state of Indiana has provided its explanation of what the sticks represent: concealment of the bodies. And Richard Allen has a Sixth Amendment right to offer the jury his alternative theory as to the reason the sticks are aligned and arranged in the manner in which they are arranged. Denial of this opportunity to present the jury all alternative explanations would leave the jury with only one explanation, the explanation provided by the state of Indiana. Now, let me just pause here because they filed this motion right after Olehay's testimony about the concealment. They file another one once it gets compounded with Holeman's testimony. Additionally, the sticks on the girls appear to be arranged in a pattern/arrangement, or at a minimum, using a person's own eyeballs. Common sense, logic, and reason could cause a reasonable person to believe that the sticks were formed into some pattern/arrangement and weren't being used to conceal the bodies. Therefore, it could or would be confusing to a juror who might think that that arrangement of sticks was intentionally placed in a certain arrangement on the bodies, but then those jurors aren't being provided with any explanation for the way the sticks are placed on the bodies in a certain arrangement. Evidence of Norse paganism, Odinism would therefore assist the trier of fact and alleviate confusion for the jurors. Additionally, it has been learned at the August 1st, 2024 hearing that the blood found on the F tree resulted in the state of Indiana retaining a blood spatter expert more than 7 years after the murder. Dr. Perlmutter's testimony would be offered in part to counter the testimony of the state's blood spatter expert, and the accused has a Sixth Amendment right to counter their blood spatter expert's testimony. Being able to provide evidence to the jury that Odinism, Norse paganism, as an alternative explanation of the stick arrangement on the girls' bodies, including the testimony of Dr. Perlmutter, would offer the following. A rebuttal to the state of Indiana's explanation of why the sticks appear the way they appear, consistent with the Sixth and 14th Amendments to the United States Constitution. B, a rebuttal as to the state of Indiana's blood spatter expert. C, an alternative explanation to any confused juror who believes the sticks and blood on the tree weren't used for concealing the bodies, but rather believes the sticks were arranged by a Norse paganist, Odinist, as part of a ritual. Defendant files this motion currently in part for the purposes of a ruling in anticipation of the need to contact our witnesses in the event that the court reverse his ruling. Should be her, obviously.
Right.
So that motion again is dealing with, and then babe, you can pull up the other one, is dealing with the state's explanation that the sticks were placed as camouflage. The state's point was that this got fleshed out more on the defense's cross-examination. Now, while that is true, that it did get fleshed out more on cross-examination, the state still opened the door. It asked questions that led you to believe that these stakes were placed by someone. They were moved on top of the bodies. So it called for common sense cross-examination of that issue. They introduced it to the point that it needed to be cross-examined, and then on cross-examination, their witness drove it home. So now that's just dealing with Olehay. We have a whole different situation when we get to Holeman. With Holeman, the state on its own just introduced this whole new second theory. So that's what we're going to get to now.
Yeah, and I just want people to understand the concept of what happened in this case, wherein Richard Allen was barred from talking about what the crime scene looked like. He couldn't bring up at all what the crime scene looked like in terms of his defense. They couldn't bring it. It's crazy. You're never going to find another case wherein you can't cross-examine the cops who were at the crime scene as to what it looked like, what they observed. Like the fact that she barred them from describing it and let the jurors make their own decision as to whether or not they think that those sticks signified anything, or if they were in the shape of something, or if they looked unusual. That's like a question of fact. That's not a question of law. Like it's one of the things, and we felt like this was something that was important for us to look at, because I'll be shocked, frankly, if this isn't an issue that's brought up in the appellate brief, which we're expecting to drop mid-December. All right. So we're going to start trying to do some things that are in anticipation of the appellate brief, and we're going to try to look forward and guess on maybe some of the issues that we think that they might raise, or that we think that they should raise, hopefully. All right, so let me just pull this guy over so it's on the other screen. All right. Okay. All right. I want to make it bigger, so I'm going to put it in over here. Okay. All right. You guys ready for the second one?
But we have to pause to give Twigs a family hug.
Aw, family hug, Twigs. Welcome, 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 welcome.
Same for you, Farmer.
Yeah, Farmer.
New member. We love our new members.
We do indeed. All right, so the next motion that was filed, and again, this is a motion in limine, which means that it was filed during the course of the trial in this particular circumstance. So after the testimony, Andy runs back to his office and pounds these two things out, because if you were following our coverage, I think every lawyer in that room that wasn't trying the case was under the impression that the door had been kicked wide open and that they were going to be allowed to, at the very least, get in the information about the sticks potentially being runes or having some kind of significance. And also, I think Andy took his shot here to try to re-litigate the third-party suspect stuff. All right, so this is the accused's second motion to admit evidence of Odinism, Norse paganism, ritualistic killing, and also a motion to admit evidence concerning Elvis Fields and Brad Holder as third-party suspects. So comes now the accused. Oh, sorry. I'm trying to make it a little bigger for you guys. Okay. Comes now the accused, Richard Allen, by and through counsel, and moves this court to admit certain evidence that this court thus far has prevented the defense from presenting to the jury, pursuant to its September 4th, 2024 order granting the state of Indiana's April 29th, 2024 motion in limine. In support of said motion, the defense states the following. On October 23rd of 2024, the defense had previously filed his first motion to admit evidence of Odinism, Norse paganism, ritualistic killings. Since that motion was filed, additional evidence has been elicited through testimony and other evidence that further opened the door to the admission of Odinism/Norse paganism/ ritualistic killing. Also, since that October 23, 2024 motion was filed, additional evidence has been elicited through testimony and other evidence that opened the door for the defense to bring in evidence that third-party suspects Elvis Fields and Brad Holder were involved in the killing of the victims. And then he's got a subsection here, which I think is a subsection. I don't know. Why is that bolded, do you think? Well, whatever. Additional evidence admitted during trial that supports introduction of Odinism, Norse paganism, ritualistic killing evidence. So on Wednesday, October 23rd, 2024, forensic pathologist Core testified that possibly two, possibly three, possibly four instruments were used to cut the necks of Abby and Libby. That in his autopsy, Dr. Core believed that some cuts may have involved the use of a serrated instrument, and other cuts may have involved the use of a non-serrated instrument, providing the possibility that more than one person was involved in the murders. During his testimony, Dr. Core backtracked somewhat, but still did not exclude the possibility that the injuries to Abby and Libby were caused by both a serrated and non-serrated instrument. Also, since the trial began, the prosecution admitted certain crime scene photographs into evidence, including photographs of the crime scene in which the sticks on the girls were clearly visible to the jury, allowing the defense to ask questions concerning the sticks on the girls. Any competent lawyer would ask a variety of questions concerning the unusual way that the sticks were placed on the victims, and it would be ineffective for the trial lawyer not to ask questions concerning the sticks placed on the victims. On Saturday, October 25th of 2024, Lieutenant Jerry Holeman from the ISP testified to the following on cross-examination. Lieutenant Holeman testified that it was his belief that the sticks and branches found on the girls were used by the killer to conceal the bodies. On redirect, Prosecutor McClelland asked Lieutenant Holeman if another reason that the sticks were found on the girls was something called an undoing. Lieutenant Holeman responded, yes. Through Dr. Kaur's testimony, it was determined that it is feasible that multiple people using multiple knives, supporting the defense theory that Odinists, Norse paganists were involved in the murders. As Dr. Perlmutter testified to on August 1st of 2024, knives are a classic sign of Odinists, Norse paganism culture, and that knives are classically used in ritualistic killings. Dr. Kaur's testimony revealed that perhaps as many as 4 knives were used, and at least one of those knives may have been serrated, supporting the defense belief that multiple Norse paganist Odinists using several knives or multiple knives were involved in the murders. Furthermore, upon viewing the crime scene photographs that have been admitted into evidence, there are no obvious drag marks to the naked eye, nor were there any police reports or charts that showed drag marks at the crime scene. Even blood spatter expert Pat Cicero admitted that he could observe no drag marks on the crime scene photographs that he received. The fact that there is no evidence of drag marks supports that more than one person was involved in the murders, including 2 or more people needed to lift Libby German's body, explaining why there was no drag marks from where she was killed to where she was ultimately found, supporting the possibility that multiple Norse paganist Odinists were present and participating in the murders. As it relates to Lieutenant Holeman's testimony, when Lieutenant Holeman answered yes, when asked if another theory of why the sticks were on the bodies was because of something called an undoing, his testimony is yet another reason provided by the state of Indiana as to why sticks are on the girls. The questioning of the prosecution and the answers of Lieutenant Holeman pertain to yet another explanation, an undoing as to why the sticks were found on the girls. And therefore, the prosecution opened the door to the defense's alternative theory as to why the sticks were found on the girls. The defense had its own theory as to why why there were sticks on the girls, and Richard Allen has a Sixth Amendment right to provide that theory to rebut the state of Indiana's theories, including the prosecution's latest theory that the sticks are related to an undoing. Additionally, blood spatter expert Pat Cicero opined or the prosecution led the jury to believe through questioning that Liberty German was moved to her final resting place to conceal the body. The prosecution's line of questioning of Pat Cicero was pursued by the prosecution on direct examination and opened the door to the defense offering alternative theories as to why the body was placed in its final resting place and why the sticks were placed on the girls. The defense's theory is that Liberty German and Abigail Williams, their final resting place was related to Norse paganism, Odinism, and a ritualistic killing. Again, Richard Allen has a Sixth Amendment right to present its theory of why the victim's body was placed in its final resting place and why sticks and branches were placed on the body. The defense believes that both Libby and Abby's bodies were placed there because of the desire of Odinists to pose the body and form sticks on the body in an arrangement for reasons only understood by the people or person that murdered the victims. Dr. Perlmutter has testified as to how the sticks would only have meaning to the people who were involved in the murders. Additionally, the defense expert, Dr. Perlmutter, indicated in the August 1st, 2024 hearing that an arrangement of sticks was not an undoing, as an undoing is typically an attempt by the killer or killers to provide dignity to the victims. Hallmarks of an undoing might be closing the eyes and the mouth of the victims. In this case, the girls' mouths and eyes were open, and one victim was displayed naked in an undignified manner. This would be inconsistent with an undoing. The defense should have had the opportunity to explain why it believes is an undoing and how the crime scene does not exhibit an undoing. So, evidence introduced before and during trial that supports the introduction of third-party suspects Elvis Fields and Brad Holder. On Saturday, October 25th, 2024, Lieutenant Holeman was asked a question about how many people were involved in the murders of the victims. Holeman answered or offered that only one person was involved in the murders. After offering that only one person was involved in the murders, Holeman offered the following as part of his reasoning for believing that only one person was involved in the murders is that based on his training and experience, when more than one person is involved in a crime, there is often a point in time when one of the participants will discuss the crime or reveal the crime, whereas when it is only one person, it is much easier to contain the secret. Wow, that's some crack police work there.
That is insane.
That was Lieutenant Holeman's theory that supported his belief that only one person committed the murders.
Come on, people. There couldn't have been more than one person, because if there's more than one person, someone's going to tell the secret.
Somebody's blabbing.
I mean, it's a fact. It's the way the world works.
Fucking monk over there.
Had to only be one.
Yeah. Since September 18th, 2023, the defense has consistently maintained that evidence supports that Elvis Fields was a participant in the murders along with Brad Holder and others. According to Lieutenant Holeman's theory, as testified to under oath on October 25th of 2024, if it is true that Elvis Fields and Brad Holder were both involved in the murders, then it is likely that one of them would have admitted to being involved in the murders or providing incriminating statements concerning being at the murders.
One of them might have done that, right, babe?
I don't know. He's got to be referring to something.
Pretty sure.
So evidence exists that supports the defense contention that multiple people were involved in the murders, and also support Lieutenant Holeman's theory that if multiple people are involved in a crime, that at least one of them will reveal the crime to others. Loose lips sink ships. For example, blood spatter expert Pat Cicero testified that it is possible that both girls were killed at the same time, which would indicate that more than one person was involved in the crime. Additionally, Pat Cicero also admitted that one explanation for Abby having no blood on her hands is that while her neck was being cut, someone else had her hands down. So law enforcement conducting the investigation into the murders have interviewed one suspect, Elvis Fields, who A, asked inculpating questions to a state trooper, one Mr. Trooper Kevin Murphy, and B, has connections to those who have incriminating evidence on their social media, as well as a direct connection to one of the victims. As you may or may not know, I'm sure most of our crew in here is aware that Brad Holder's son was dating Abby. Therefore, evidence exists that multiple people were involved in the murders, rendering all purported alibis as suspect due to the ability for the ringleader to claim an alibi while others are doing his bidding in terms of abducting the victims. Also, I would have added, in order for you to believe any of the third-party suspects' alibis, you have to believe the state's timeline is right. I don't think their timeline, attack the timeline. And I'll leave it at that. Brad Holder's first alibi, for example, would allow him to be in Delphi. Oops, let me skip this over. be in Delphi no later than 2:30 p.m., perhaps earlier, while Elvis Fields and others abducted the victims and held them awaiting Holder. In 2018, law enforcement pulled Elvis Fields in for questioning to the Rushville Police Department and at the end of the interview took Elvis's DNA and then explained to Elvis their reason for taking his DNA. At the conclusion of the interview, Trooper Kevin Murphy drove Elvis back to his home. After Trooper Murphy dropped Elvis off at his home, Elvis walked towards his home, then turned around and approached Kevin Murphy's car. After getting close to Trooper Murphy's vehicle, Elvis asked Trooper Murphy, "Hey, if my spit is found on one of the girls, but I have an explanation for it, would I still be in trouble?"
It what is the judge thinking?
I don't know.
How is that not a nexus?
I don't know, man.
If the appellate court doesn't find that that was sufficient, I don't care if they find any other reason, like, yes, she should have let it in, but it's harmless for some reason or whatever. If they don't find that that was an issue, you just shoot me now.
I mean,
I mean,
agreed. All right. So, additionally, evidence exists that supports that Elvis Fields was mimicking Brad Holder, who lived 125 miles away
wait, you
and
just
should
skipped
have no
DNA
tie.
analysis
Oh,
analyst.
sorry. DNA analyst Stacy Bozanowski testified at the end of her cross-examination on October 28, 2024, that a person's spit can, in fact, be analyzed for DNA. Yeah, no shit. What? I mean, everything that was found on the body should have been tested, and it's unbelievable to me that it wasn't. All right, so back to 36. So additionally, evidence exists that supports that Elvis Fields was mimicking Brad Holders, who lived 125 plus miles away and should not have ties to Elvis Fields' Facebook posts, or that Brad Holder was mimicking Elvis Fields' Facebook posts months before the victims were abducted. Elvis Fields has claimed under oath that Brad Holder was actually mimicking Facebook posts that Elvis Fields had posted. So Brad Holder's son, Logan, was dating Abby Williams, and Brad Holder had evidence that exhibited Holder's knowledge of a crime scene on his social media that no one else should have known.
Something
Meaning,
only the killer knew.
yeah, legit. And if you've never seen those posts, they're pretty shocking in terms of just how close they are to exactly what the crime scene looked like. Fields, who seemingly would have no reason to know Brad Holder even existed, A, followed Brad Holder on Facebook, mimicking his posts, or vice versa, and B, was making statements that inculpate him as to being involved in the murders, including the expectation of the possibility that Elvis's, spit might be found on the girls. However, this would not be surprising based on Lieutenant Holeman's October 26, 2024 testimony that when multiple people are involved in a crime, somebody will ultimately spill their guts. So additionally, evidence from Brad Holder's social media supported the concept that others assisted him in committing the murders and moving the bodies, as Holder posted a meme on his Facebook page a few days after the girls were murdered. And the theme and words from that meme have become more important due to testimony that has been elicited during trial. According to blood spatter expert Pat Cicero, Libby's 200-pound body was in fact moved from one location to another. Also, pursuant to blood spatter expert Pat Cicero, there were no drag marks that could be seen on the crime photos. And just noted, Pat Cicero never went to the scene. When he went out and did his own little experiments, it wasn't at the scene. Just so we know. And he wasn't there. He came in years after. Like, he was hired by the state before trial. Okay, so this dude's testing had nothing to do with the crime scene. He never laid eyes on the actual crime scene. So he had to completely and totally rely on any photographs that were taken of the crime scene. Okay, so therefore, evidence supports that Libby's body was moved from one location to another, and that two or more people would have been needed to carry the body since no drag marks existed. Certainly, it would be highly unlikely that one man alone could accomplish that task. On February 17th of 2017, 3 days after the murders, Brad Holder posted these words on his Facebook page. Your real ones don't judge you or ask a bunch of questions. They help you move the body and never speak of it again.
If there
Emphasis
was
on it.
something like that on of course Richard Allen's social media, but any other case, the state would be flailing it around as consciousness of guilt and and it'd be getting into evidence.
100%. Well, I mean, to stick it on Richard Allen, this would have been like Exhibit A.
Right.
This would have been they would have opened with this. Like, it's that powerful.
Right.
And again, I just want to restate, if you forgot from 3 minutes ago, Brad Holder's son, Logan, dated Abby. There's a direct connection. A direct connection. So the fact that Brad Holder had content on his social media that mimics the crime scene in parentheticals unknown to the public at the time. And so, in case you're newer to Delphi, they kept the crime scene and what its condition in terms of what it looked like on the hush hush, super down low. The public didn't know. There were, of course, rumors, but nobody knew for the 5 years preceding what the crime scene actually looked like. And there were some leaks that had happened early on, but no one knew. All right. And especially Brad Holder. Brad Holder would have no fucking reason to know other than if he was there. So, or just a wild guess, just a coincidence, a wild coincidence. It's hard to believe that concept. The fact that Brad Holder had told multiple stories about whether he had ever met Abby Williams, ranging from he never met her to he met her one time to he met her 2 times, along with all the other evidence provided in the Franks memo, supports that third-party suspect evidence should be made admissible. Additionally, the evidence previously provided to this court in the Franks memo, as well as admitted into evidence on August 1st of 2024, provided proof that Elvis Fields did not have an alibi that could be substantiated, but quite the opposite. Elvis Fields' alibi is sketchy, as his version of his whereabouts on February 13th of 2017 runs counter to those who had allegedly were with him on that day. In other words, no one could keep their stories straight about Elvis's whereabouts on February 13th, 2017. Lieutenant Holeman's October 26, 2024 testimony leaves the jury under the mistaken belief that no evidence exists, that multiple persons were involved in the murders, and that no other suspects have made any statements that inculpates them in the crimes, thus supporting Lieutenant Holeman's theory that when multiple people are involved in a crime, at least one of them will ultimately reveal the crime. At the time of his October 26, 2024 testimony, Lieutenant Holeman was fully aware that evidence existed that Elvis Fields made inculpatory statements concerning being present at the scene at the time that the victims were murdered.
That is a very, very important point because they allowed him to testify. As stupid as I think it is, but whatever. Almost like an expert witness, an expert police officer that in his experience, if there are more than one person, someone talks about it. Someone reveals it. And then he had evidence that somebody did just that. I mean, this is it's something that I hope the appellate court takes into consideration, especially in conjunction with the other stuff. But you don't put a guy on the stand to say, well, one of the reasons I know it wasn't 2 people is because if it was 2, one of them would have talked.
Yeah.
And then he's got evidence that someone who just because they don't think was involved in it talked, doesn't matter.
Yeah, and it was important for the defense to file these motions and eliminate during the trial in order to really kind of nail for the appellate court that this is an issue that not only came about pre-trial and they were denied the ability to be able to present third party evidence, but that this issue rose up again because based at least on the opinion of the defense, the state opened the door. So it's important for them to have filed this because it's going to really allow them to be able to bring in this concept of Holeman in terms of, hey, look, it could only be one dude because if there's more than one person, somebody's blabbing type shit. And say in the context of that, well, here you go. All right. So because they didn't have that during the pre-trial, right? They didn't have Holeman saying that was why his theory had all of a sudden over the course of when everybody thought there were multiple people that had committed these crimes in the beginning. And then of course, conveniently dropped that theory.
I mean,
they arrested Richard Allen.
They had 2 different people depicted
Yeah.
in their sketches. So don't worry about that first guy.
Like that is definitely the same dude, right?
Don't worry about this first guy. Now we're asking about this second guy. And
This
even
other
after
guy.
they arrested Allen, they were still asking for any additional information the public might have about anybody else who was involved in the crime.
Yeah, the young poofy hair guy. All right, so I can't remember if I read this. I'm going to read it
49.
49?
Yep.
Oh, wait, I think it was actually
Oh, no, 48. Sorry.
Yeah, at the time of his October 26, 2024 testimony, Lieutenant Holeman was fully aware that evidence existed that Elvis Fields of Rushville, Indiana, had a connection with Brad Holder from Logansport, Indiana. And in fact, said evidence produced from the law enforcement investigation showed that Brad Holder and Elvis Fields were mimicking one another on Facebook.
And not just randomly, like he said, they were friends on Facebook.
Yeah. Yeah, and look, would you kind of get into the whole Elvis Fields when you really go into that rabbit hole? You know, if you're not aware of it, you know, he had purportedly confessed to his sisters the day of, and you know, the sisters a few days later, you know, feeling an obligation to report it to law enforcement, do just that. They bring at least one of the sisters in to do a polygraph. As to the question of, are you being truthful that your brother told you this information? And she passed the poly, meaning
I'd be surprised if that's not in here. If it's not, it was an oversight because there you are again talking about more than one person. Someone reveals something to someone and he confessed to his sister.
yeah, I mean, Elvis clearly just has a big mouth. All right. So at the time of, oh, wait, was I still on 49? Mimicking one another on Facebook, blah, blah, blah. Lieutenant Holeman was fully aware. Yeah. Okay. So at the time of his October 26, 2024 testimony, Holeman was fully aware that Brad Holder had evidence on his social media consistent with signatures left behind at the crime scene, including a mimicked crime scene photograph that looked eerily similar to the way that the bodies were posed on the ground of the woods and the photographs of sticks laid down on the ground, and a similar pattern of sticks found on Abby's body in the form of a hand-drawn pattern on the wrist of Brad Holder, among other incriminating items, including a post about real friends helping move bodies. At the time of his testimony, Holeman was aware that the Odinist Norse paganists had been investigated as being involved in the murders. At the time of his testimony, Lieutenant Holeman was aware that both Brad Holder and Elvis Fields possessed knives, and that Brad Holder used knives as part of his Odinism religion. At the time of testimony, Holeman was aware, or should have been aware, that Brad Holder possessed a .40 caliber handgun. At the time of testimony, Holeman was aware, or should have been aware, that Brad Holder's 40 caliber handgun was never collected, test fired, or compared to the bullet allegedly found at the crime scene.
All right,
Therefore,
so this is where it should say, at the time of his testimony, Lieutenant Holeman was aware or should have been aware that Elvis's sister said he confessed to her.
yes, agreed. So therefore, the jury has been misled into believing that law enforcement's only available evidence only supports that only one person was involved in this crime. When Holman's own words on the stand, evidence from the law enforcement investigation and trial testimony from Dr. Core, Pat Cicero, and Lieutenant Jerry Holeman would support the defense theory that multiple people were involved in the crimes. This is true because Elvis Fields has provided inculpatory statements and has social media connection with Brad Holder, and Lieutenant Holeman has indicated that when multiple people are involved in a crime, it is in his experience that one of the participants will ultimately reveal the secret of the crime. It is also true because a substantial amount of evidence supports that Brad Holder's social media contain words and images that are consistent with the crime scene and also consistent with creating or showcasing an alibi at 2 a.m. on February 14, 2017, when for the only time in his life, he claimed in a Facebook post that he was at the gym, as Holder stated under oath in the deposition. Holder's social media is also consistent with others being involved and assisting him in moving the bodies. 56, Richard Allen possesses a Sixth Amendment right to rebut Holman's theory that one man and only one man was involved in these murders, especially when Lieutenant Holman's reasoning for believing that one man was involved in the murders is debunked by the evidence detailed herein, including Elvis Fields' inculpatory statement that supports Lieutenant Holman's belief that when multiple people are involved in a crime, ultimately one person will reveal the commission of the crime. Additionally, as previously detailed, Richard Allen possesses a Sixth Amendment right to present evidence that those involved in Norse paganism, Odinism, were involved in the murders and posed the girls and placed the sticks on the girls in a certain arrangement for reasons that are very personal to the people that committed the crimes. Defendant files this motion currently in part for the purposes of a ruling in anticipation of the need to contact our witnesses if the court reverses her ruling. End motion. All right.
So now I'm going to bring up the
transcript.
Yep, the judge's ruling. Oh, whoa.
Hello?
Hit the wrong button.
Oh boy. Oh boy. Oh boy.
All right. So this is the judge brings this up. So the judge says, so I'll read.
Make it bigger, please.
Okay.
Thank you.
So one of us has to read the court. One of us has to read Baldwin. One of us has to read McClelland.
Who do you want to be?
I'll be the judge and McClelland.
Okay.
The last thing then is your motion, Mr. Baldwin.
Judge, to make it simple, I would just stand on the motion itself, both of them.
So no additional arguments?
No additional.
Mr. McClelland. Judge, if I understand the motions, the defense is claiming that we've opened the door by questions that we had. And I hope I can cover all of these issues here, but I believe in part it was from the testimony of Core and perhaps Olehay and then Holeman. I don't believe the state has opened the door at this point. Specifically to Olehay, they initiated the questions as to how the sticks were arranged. And with Holeman, they initiated those questions. No. Any questions after that were just follow-up questions to clarify the questions from the defense. And so the state does not believe they've opened the door at this point to allow that third-party motive or third-party evidence into the trial, Judge. Anything else?
Yes, Judge. Certainly, Judge. When the state puts in evidence of sticks on these girls in what I would label in a very unusual way, especially on Abby, that invites questioning from the defense of the witnesses. So I would say they open the door is the way it would be ineffective assistance of counsel for me not to ask the questions about that. And therefore I asked questions about that. It's not door opening. It's cross-examination based upon what they put into evidence. So I would say that. Then there's the whole situation involving the undoing. That was definitely not offered by the state, by the defense. That was offered by the state of Indiana on redirect by Mr. McClelland, who asked, was it also thought that the reasons for the sticks on the bodies was an undoing? And the answer was yes. And not, so we have different opinions. It is not an undoing. It is from Odinism. It is, wait, you fucking lost me there. It is from Norse paganism. We have an expert that has testified to that. And certainly the state has invited opening the door through that questioning. And that should be allowed to put in our own reasons as to why we think those sticks were on the girls and how they were formed and so forth. And that's a Sixth Amendment right that Mr. Allen has. And then, I'll just let the other argument stand. Judge, as it relates to, Lieutenant Holeman saying that only one person was involved, because more than one person, if there are more than one person, then it's going to leak out because more people can't, basically there's just more opportunity for that information to leak out about the crimes. And certainly through the Frank's memo and through testimony on August 1st, we have learned that Elvis Field said and asked the question, if my spit is found on the girls, but I have an explanation for it, would I still be in trouble? I would call that an incriminating type of comment or question. And then we have the linkage between Elvis and Brad Holder. Therefore, what Lieutenant Holeman said on the stand bears itself out to be true, that more than one person, in our belief, are involved in the crime. Elvis Fields made an incriminating statement. We believe there's strong, evidence that a guy 125 miles away in Rushville and a guy up in Logansport who are following each other and mimic each other on Facebook, that is an inexplicable connection. That the common denominator is the Delphi murders. Brad Holder, as you know, Judge, his son dated Abby, and Elvis Fields said that, asked the question that he asked. Therefore, I think when Lieutenant Holeman stated that more than one person, I only believe it's one person for a lot of reasons, one of them being nothing. Nobody's going to admit to it if it's just one. It bore itself out. So it's been a long day. I'm going to sit down, and I'm going to stand on that. Thank you.
Anything else, Mr. McClelland? Judge, just the same argument. Those are questions elicited by the defense, and so they're trying to use their questions to then open the door for their third-party suspects. Any questions asked by the state were in response to the questions asked by the defense, and so I believe they are trying to open the door and allow this stuff in, and so I don't think the state does not believe it's proper at this point to allow that kind of evidence in, Judge. The court. Well, again, the case law is perfectly clear about third-party suspects, and there has to be a nexus, and there is no nexus. There's still no nexus between third-party suspects and the crime. So both of the motions that you have filed, Mr. Baldwin, are denied.
Thank you, Judge.
And there you have it.
There you have it.
So just the argument that the state is making here, and babe, I'm going to go back to page 8 of my notes, is really what the defense did. Like, they're saying, well, we only asked follow-up questions because of what the defense asked. But they the defense asked those questions as follow-up questions to what the prosecution asked. They started by talking about sticks were on the body and debris was transferred to the body and that it was covering a large wound. It was implied through those questioning that the sticks were placed there by a person. So that was the defense following up as they have to do, cross-examining him about what was implied by his testimony. And then the prosecution is trying to reverse that and say the defense tried to open the door on themselves. And like I said, the defense questioning of Olehay did allow Olehay to get in even more about the concealment and that he thinks it was to hide the body, but it all started with the state's line of questioning, and you saw the same thing with Holeman. And then again, as the motion points out, they put that whole undoing in completely of their own. So on that last motion, let's just go over what they're saying. One, the state initially said the sticks were for simple concealment. Two, on redirect, the state introduced a second theory that the sticks were an undoing with a psychological significance. Three, by introducing the second theory about the psychological and behavioral meaning of the sticks, the state opened the door to the defense's theory about ritualistic significance. I agree. Four, Dr. Perlmutter excluded expert testimony should now be admissible because she can rebut the undoing. In addition to that, you heard the evidence that spoke to more than one person being involved and the expanded nexus between Holder and Elvis Fields.
Yeah, I mean, that's exactly right. And the defense is also arguing that they have a constitutional right to present this alternative theory, especially now that the state has introduced the concept that the sticks had psychological and behavioral meaning beyond mere concealment. And that word, the undoing, is what did it.
Right.
That's what undid their ability to be able to keep that shit out. They opened the door. It should have been allowed in. I mean, beyond that, her not allowing, her being Gull, not allowing the defense to even question their witnesses as to what the crime scene looked like. And then when the jury sees this, like these crime scene photographs, and then they're not allowed to, like, not one juror looked at them and was like, oh, shit looks kind of weird, because Auger was able to get Cicero to admit that I think that the sticks only covered, like, I think they landed on 3% of the girls' bodies, right? So it clearly wasn't for concealment.
Right.
And there was some, I can't remember whose testimony was, but it was like, oh, well, I stood across on the river, and if you were on the other side of the creek and you were looking over there, those sticks might have hid the bottom. Like, what?
And that's why we touched on all of the footprints, in the testimony. How are there's these multiple footprints. So either people are walking around there not seeing the body before the police get there, or there's more than one person, at the crime scene involved in the crime, because they're saying that the kids didn't have shoes on at that point. So, all of that plays into this. So let's start with, did the defense open the door?
Yeah.
And before we get to our opinion, let's make sure everyone understands what opening the door legally means.
Right. So opening the door is a doctrine in evidence law, and it's this basic principle that if one party introduces evidence or testimony on a particular subject, they may open the door to rebuttal evidence on that same subject, even if that rebuttal evidence might otherwise be inadmissible.
The classic example is character evidence, right? I mean, normally you can't bring in character evidence. You can't say the defendant is a bad person or the defendant has a history of violence. But if the defense opens the door by putting their character at issue For example, they put on someone to say that I know this person to be a peaceful person. Well, now the prosecution gets to rebut that evidence with the defendant's violent history. So the key is you can't introduce half the story and then claim that the other side can't complete it. But you also have the Sixth Amendment right to the jury getting a full picture. When Holeman, sorry, I'm trying to find my charger. When Holeman testifies that there's no evidence that it was more than one person, that all of those things, and when he testifies about, and especially the undoing, because the concealment, they knew damn well that concealment made no freaking sense, especially when you're talking about 3%. Oh, there's just the 3 sticks, so that's why they had to introduce this undoing.
Right. Yeah, and I mean the bottom line is you can't have it both ways. If you open a topic, meaning like the state, for instance, you can't then turn around and complain when the other side responds to what you said on cross.
Right. And then your witness throws in whatever the hell they want. It's still coming in through your witness.
Right.
All right. So applying that to this case, let's walk through the chronology.
All right. So going back to the pretrial motion phase, and again, the 3 days of hearings, Gull excluded all the evidence about Odinism and the ritualistic significance of the sticks and Perlmutter's expert testimony, all of it out.
Right. So the door closed and locked.
Exactly. And then during trial on direct, the state's witnesses, Olehay and Holeman, testified that the sticks were used for concealment or camouflage. That was the state's theory.
Again, as we saw on cross-examination, the defense asked about the concealment theory. They tried to poke holes in it, that the bodies weren't fully covered, that the sticks were collected days later, but they were asking about the state's theory.
Right. I mean, nothing new introduced on cross, but then on redirect,
prosecutor introduces the whole undoing.
Oopsies. I mean, that, like, the way that opening, like, if you guys watch trials, and I know you do, I know a ton of you watch trials, the opening the door shit happens like in the blink of an eye. It's when somebody fucks up and utters something that they shouldn't have said on the stand, and whether it was elicited by the state's question or whether it was the witness just screwing up because he wasn't prepped properly, like, hey, you got to avoid anything having to do with sticks or runes or undoing and anything that even revolves around that type of language, because otherwise you're going to open the door and allow them to get that shit in. So once it happens, it happens.
Right.
Right. So the prosecutor on his own redirect asks Holeman if another reason for the sticks was something called an undoing, and Holeman says yes.
And that's significant because the state asked a leading question. The state introduced it. It wasn't like he just came out with it on his own. The state literally asked him. So isn't it also something, didn't you also determine it's something called an undoing? So now the state's introduced 2 explanations, concealment and undoing. And again, on the direct of Olehay, it was subtle, but it was definitely implicit in their questions that somebody intentionally put the sticks there. So that's what gives the defense the ability to cross-examine them.
And like, I just want to clarify how significant the fact that he basically introduces 2 theories, the concealment and the undoing, like Ali just said. And like, if you're sitting there like, well, who cares? It's basically the same shit. No, it's not. Undoing is fundamentally different from concealment. Concealment is practical. Like, like I'm gonna dig a shallow grave and I'm gonna put them in and I'm gonna cover the body, or I'm gonna take a bunch of sticks and leaves and I'm gonna cover the body. That's not what this was. I'm trying to hide the evidence of my crime. That's what concealment is. Undoing is psychological. I'm experiencing remorse. I'm trying to provide dignity to my victim. I'm symbolically trying to reverse what I've done.
Right. And, maybe the appellate court's going to be like, well, they didn't really even explain to the jury what it means. So, yeah, I don't think it had all that much impact. And it's possible that they will say that. But I think coupled with the concealment, that it was no matter how the door was open, he had a Sixth Amendment right, a right to a fair trial, a right for the jury to hear the full story, a right for the jury to hear the defense's theory, no matter what, you know?
Yeah,
So
like the one thing that I think might help, even though it wasn't exactly on point, was the juror question.
right.
You know what I mean? Because it's like at least you have some actual knowledge if you're the appellate court that at least one of the jurors picked up on it, which to me is significant, So, I mean, we'll see how it plays out. We'll see. To me, this is death by 1,000 paper cuts type deal, as opposed to like one particular issue, unless it's chronic. If it's a chronic thing, then this thing is getting kicked back. And Osbrook's, dead set that thing is automatic retrial. So,
Right.
I mean, I hope he's right. It's like you always wonder if an appellate court, they're like you've said it a million times, babe, like they are going to do everything in their power to avoid having a retrial. I mean, they are not in the business of having the courts retry cases, especially significant high profile cases wherein they know there's a ton of publicity that goes along with it. And I mean, can you imagine
Right.
what's going to be going on when and if Richard Allen gets another trial? Like, I mean, I think that there would have to be a massive push to get this thing streamed, to try this one in the light, and my hope is obviously that Gull's not sitting on the trial again. I hope that the appellate court, that would be one of the things raised in the appeal wherein they're saying, okay, and I'm talking about Rick's appellate attorneys are saying, look, this judge cannot sit on this case again. Like, I mean, you have a legion of shit that she fucked up. Starting with her docket. Her docket was a mess, and it continued to be a mess after she reinstated Rosie and Baldwin.
All just to hide everything from the public. It's insane.
Oh,
it's
I can't.
insane.
The clock is ticking on the
Yeah.
Franks exhibits.
Yeah, right.
That clock is ticking. So I'm going to be curious to see if they come up with them. Like, I mean, look, and I just want to be clear. I addressed this on Twitter some. People are like, well, what happens if they're like, fuck you, we're not going to forgive. No, it doesn't work like that. This is a court order, okay? And they have to provide it, or it's indirect civil contempt, or potentially criminal contempt. And if you're in contempt, you can throw your ass in jail. So
did the appellate court rule on that other motion about you need to tell them they have to turn this over?
Oh, wait, didn't you hear? You weren't on the live when we read the court order? Yeah, like they have 20 days. Maybe you didn't see my post. Maybe we didn't do a live on it. Yeah, the court ordered, the appellate court, not the Supreme Court, ordered that they have 20 days. Jody Williams, who is Gull's clerk, and Judge Gull have 20 days to provide the appellate counsel with the exhibits, and that they have to give new notice of the record being complete. So, like 20 days, and then there's 5 days to get the notice in. And
that's why they have till mid-December.
Correct.
Yeah, you didn't do a live. You just tweeted about it.
Yeah, sorry. It would have been short. It would have been like a 10-minute live.
All right. So, I mean, I said it earlier. One of the, like the judge didn't give any explanation for her ruling other than saying that there's no nexus. I mean, she didn't even
give an explanation.
Right. She didn't even touch on the undoing or the sticks. She just said no nexus. You don't need a nexus to describe the freaking sticks, Your Honor, to provide another reason that the sticks are there. That's not a third party. It's just someone out there in the world that, had a psychological reason for putting them in a certain shape. That's all it needs to be said.
Right.
So, but one of the things that I mentioned earlier that the court could find, the appellate court could find as rationale, was that Holeman's testimony about the undoing was so brief, it wasn't developed extensively, so it didn't truly open the door to a whole alternative theory.
Do you buy that?
I mean, no, because it's not about how long someone talks about something. It's about whether they introduced a concept, So, but I could see the court saying that it didn't really introduce a psychological or behavioral significance, a concept that the sticks had a psychological or behavioral significance because no one knows what an undoing is.
Right.
Um, but they don't know what the jury knows.
Right.
They
Well, I
said the
mean,
words. They said the words. I think
right.
that should be enough. I'm just trying to, think
Devil's
about,
advocate. Yeah.
yeah, like what they
What's
might,
going on in Gull's brain, which
or
must
what
be a
the appellate
terrifying
court
place.
might. I don't think that's what Gull's thinking. I'm just trying to say what the appellate
Yeah,
court might
all
think.
Gull's thinking is there's
I
no
said no.
nexus, and that's
There's no
it.
nexus.
There's no
Right.
nexus. No nexus. Ta-ta! Yeah.
And another
So
thing that they could find part of it was the defense opening the door themselves, but that ignores McClellan, what he did on redirect.
right.
I mean, the defense asked, was it concealment, staying within the state's theory? And then McClellan just left that there, and he affirmatively introduces a new theory.
All right. So
So,
what like let me throw this at you. What about the argument that undoing was already part of the state's evidence plan so that it wasn't really new?
well,
By
that would make
that,
it far worse for the state because if that was their theory all along and they plan to introduce a behavioral and psychological interpretation of the sticks arrangement all along, how's that not opening the door to other psychological and behavioral interpretations?
well, yeah. And here's something else. Perlmutter had already testified at the pretrial hearing that her testimony was on the record, and she said this was not an undoing because of the victim's eyes and mouths were open, and one was displayed naked in an undignified manner. So,
I mean, right. I mean, the state introduces an undoing as their explanation when the defense already put on an expert who testified it's not an undoing. That has got to make it worse. How is that expert's testimony not directly relevant now that they do that?
it's a direct rebuttal to the state's theory.
Yeah.
Period. All right.
Uh,
So,
so I mean, the state's theory that the from the beginning that the stakes were the sticks were placed by the killer, whether the placement was for concealment or an undoing or any other reason, is uh, you know could they say it's a nuance within the state's overreaching theory, but the defense wants to introduce an entirely different theory that someone else planted the sticks there as part of a ritual? I don't know. It's I just don't see how they're gonna argue that that's not relevant.
I
It's
mean, I think that the issue is going to be that that was just the defense's way. But if you bring up the sticks, right, and that they're arranged in a certain way, I think in the minds of the appellate court, they're going to be like, all right, well, that was just the defense trying to get that third party culprit shit back in because obviously that opens the door to the argument that this is multiple people that did this.
right, but
Especially with the drag mark thing. I mean, the drag mark thing to me is incredibly important. I mean, look, Rick Allen is 5'4", 5'5", whatever, somewhere in that range. He's not a big guy, which, if there's no drag marks from where they know that Libby is killed because her blood is found there to where she's ultimately found, I mean, it's a distance of somewhere between 6 and 10 feet, right? And that would mean that Allen would have had to have picked her up and carried her there and then turned her around in theory and then placed her down.
right.
And then the other problem is that you had Cicero testifying that the blood was running up, okay, which again would to me would signify that either she was picked up by two people with one person holding the face lower, because again, we don't have the drag marks. If you have the drag marks, okay, and you're seeing that in the ground in the dirt, then that would make sense if the killer had grabbed the feet and
He'd have
dragged
to get
by
her
the
off
feet.
high enough where blood's dripping.
Well, that's what
not
I'm
just
saying.
pulling.
If you've got the feet and the head's down,
Yeah, but
one person.
yeah, but babe, think about it. If you've got the feet, your back and your head are staying down. The only way the head is blood blood could move from the legs upward, but how is it getting from the face upward unless they're literally elevated that high with the back off the ground so that the blood's, you know, going towards the face?
Well, all right. So imagine that these are the feet, right? And this is the head. Okay. That's how.
Yeah, but
If
all
I,
right.
all
But
right.
what I'm saying is you have to get that body, the back and the torso up.
What? That's what I'm talking about. They're picking up the feet.
But
Here, I just
just
showed you. I'm
that's
going
the
to show you
feet.
again. These are the feet. I'm lifting the feet. The head's
Just
here.
right, but you're lifting just the feet. The butt is still on the ground.
Oh no, I'm thinking like
That's someone
you're really lifting it to where I mean,
well, that has to be somebody
apparently you
tall
haven't
and
dragged many
strong.
bodies.
That has to be somebody tall and strong to get them.
Okay. All right. I agree with that.
All right.
All right. Um
So anyway, what I was starting to say was that if the prosecution makes the argument that this was just which is what they I mean on appeal and which is what they were doing at the trial level, that this was just the state trying to get in their third party arrangement. Now we're just talking about the sticks, not the part where third party culprit theory. That the defense isn't just saying someone else did it. That's not what they're saying. They're saying the arrangement of these sticks had significance that goes beyond what the state claims. And once the state opens the door to the topic that the sticks have a psychological, behavioral, symbolic significance, as opposed to just randomly being thrown there for concealment, the door is open to other interpretations of that significance. And the defense has a constitutional right to present their theory. So I just don't think that the idea that this was all just to get evidence in that somebody else did it and get a third party in is going to clean this up.
yeah, and you know that darn Sixth Amendment, right? That incredibly important amendment. You know, the defense has a right to present a defense. They have a right to call witnesses. Courts have repeatedly held the defendants must be allowed to present alternative theories, especially when those theories are supported by expert testimony and physical evidence. So, you know, I don't know, man. It's like, to me, there's so much in terms of ripe issues that the appellate court is going to have to look at and deal with in terms of, I mean, they're going to really have to do some serious digging to be able to justify, in my estimation, not giving Richard Allen a new trial based on everything that happened, not just at trial, but during the pretrial, because those 3 days of hearings that took place, and we had Andy on, I don't know what, a couple of weeks ago, you know, and he was talking about like his experience in terms of trying to get everything that he wanted to get in terms of argument and witnesses, and it was so rushed. And we're talking about a massive case here, you know, where she had all this time to have a hearing set, and then she waits until the end of July, you know, into like August to cram everything in to 3 days, and is like, look, you've got exactly 3 days to get this shit done because there is no more time. And you know, that's on her. That's
Right.
on her not managing the case properly. That's on her for not setting things for hearings when the defense is begging her to set a hearing and she just wouldn't do it.
Right.
And remember, I don't want people to forget this point. The third party suspect stuff, which the defense again was begging through, they wanted a Franks hearing, right? Or to find out if they could get a full Franks hearing. And she ends up like mentioning to McClelland, hey, you know, you might want to like address this third party thing. Like, I mean, does the state, are you going to file a motion like barring the third party thing? Or, So then that's when McClellan finally files something. So
Right,
she,
she's basically signaling, "I'm gonna say there's no nexus," and
yeah,
it seems the state thought the nexus was so damn clear, they didn't even file a motion to keep it out.
right,
I mean, they didn't think there was a way to keep it out until the judge said that. Then they're like, "Oh, shit, she's gonna exclude this?
yeah,
Oh, hell yeah, we're on it." I
yeah,
mean,
no
come on.
doubt, no
Come on.
doubt.
I think it's a strong appellate argument when you look at the transcript and you see McClellan affirmatively introducing the undoing, and then you like we said, you got Perlmutter's already testified specifically that it wasn't. I mean, it's a compelling argument that excluding this evidence was unreasonable, and the defense would need to show that Judge Gold's ruling was arbitrary, unreasonable, or contrary to law. I think it's there, especially when the stakes are this high and the charge is so serious, someone's life is literally on the line. But let's talk about broader implications. Let's zoom out for a second. What does this case tell us about how Indiana courts handled the whole trial?
I mean, in terms of, I think it's part of a pattern that we saw throughout the case. Okay. The defense was fighting with one hand tied behind their back the entire time, or maybe like both of their legs have been cut off,
Right.
So the Odin stuff was excluded. The Franks hearing was delayed, which actually never actually took place, and then essentially became meaningless because remember that thing that happened where Baldwin was able to get witnesses on the stand was not a Franks hearing or his ability to be able to get a Franks hearing. That was McClellan's motion to bar third party suspect testimony. So then, I mean, everything became meaningless for them.
Right. And
I mean, at that point, they're having to rely strictly on reasonable doubt.
and like you said, like the defense had to litigate with limited resources while being held in contempt, sanctions, removed from the case for a period of time. So when we talk about whether Judge Gold was right to exclude this evidence after the state opened the door, we're not just talking about one evidentiary ruling. We're talking about a systematic limitation of the defense's ability to present their case.
Do you think there was bias?
I know you joke. What do you think, babe?
Yeah, I mean, I think there was a determination to keep the evidence away from the jury, and like why? I'll never know. It's like that $1 million question of, okay, why is she doing this? Like why is she like? Look, we talk about it all the time. A lot of judges are stateside, where they favor the state. Like that is not unusual. This was a whole different beast. Like from the beginning, when you look at this case from the very, very beginning to when the safekeeping order is put in place without Allen or his attorney being there. And then Rosie tries to get that thing aced, right? He goes in having, has a full hearing on the safekeeping order and he wants that to be removed so that they can get Rick out of Westville. And and it's like, and she's calling them liars. At that hearing, you could just sense, like, for whatever reason, I was just sitting there. I'm like, what? Like, when I'm in the courtroom, and this is before any other lawyers were there. I was the only lawyer in the courtroom that wasn't trying the case. And I'm like, what in the fuck is going on? Like, what is she like? I've heard judges come at lawyers, and namely you and I, right? Like we've had them where we're like, well, we're about to give you something that law enforcement's full of shit here. And then the judge, fires on us. Oh, you better be able to prove that up or I'm going to report you to the bar, that kind of shit. This was different. Like this was Gull. Like after McClellan called Rosie a liar, like Gull's saying that he's being untruthful, which as we learned later, when they finally got the stuff from Westville in terms of the recordings, in terms of everything else that they got from the prison, it became clear that he was telling the absolute truth. in terms
Right.
of what was going on with Richard Allen in that jail. And then it just progressed like all the way through to
I
where,
hope that they can use, like, all of that from beginning to end to that the appellate court will say, "We have to view this judge's rulings with a little more of a critical eye because of this, like, like, the way she viewed the lawyers, the way she viewed the case, the way she didn't believe anything." Like, that we have to take what she showed her hand. When someone shows you who they are, believe it. She showed what she thought, and it's evident in her rulings, and maybe where other judges would get a more deferential view of their rulings. Maybe this stuff can be used and the court's going to be like, all right, well, we can't give her as much deference as we give every other judge because of all in this situation, not her overall, because of this issue. But courts don't like to do that.
yeah, I
They
mean,
don't
and that's such an important point that you're making because courts will, and I'm talking about the appellate level and above, will bend over backwards to protect judges. Like they don't like shitting on judges. They don't like overturning cases based on the judges fucking up. So they're going to go to great lengths to avoid that. And you're exactly right. Like that's got to be what the hope is. That the totality of the circumstances make it impossible for them to not look at her conduct and her rulings and her lack of giving any kind of rationale as to why she's denying things and denying them without hearing. And again, we said this when we were going through all the motions back when it was happening. We're like, look, there's certain things in terms of motions that are filed that you don't have to have a hearing, but there's others that absolutely require a hearing, that they have an absolute right to get in front of the court in order to make a record and to put on what they think is going to matter to the appellate court in the event that their client is convicted, because they have to make the record. And she just denied everything without
right,
hearings. Everything that the defense filed, she denied without hearing until we get to that 3 days. And
right,
again, I want to restate it because it's so important to remember. This was not a Frank's hearing that happened in August. This was Nick McClelland's motion to bar the third-party suspect stuff, which the idea was planted in his head at the behest of the judge.
right.
And that's
And
fucked up.
look, I don't know that the court will have an issue with the Frank's hearing not going to a full hearing because the judge says, even though I don't believe it, you don't believe it, that she even listened or reviewed any of that shit. But if she says, even if everything you said in here is true, I'm not granting a motion based on that. I'm not saying that the search or the arrest or anything was unlawful. She doesn't need to go to a Frank's hearing, but
What?
to limit the time for the hearing on the third party to 3 days, that was unreasonable. That was unreasonable. Didn't give them enough time to even present their theories and the evidence.
Yeah.
Oy,
Yeah. I don't know. All right. So
let's
let's
see.
bring
We've
this
got
thing home. Let's bring it
let
home.
Yep, we've got Ian Warren 11 became a YouTube member. Let me give you everyone else before you start giving out hugs here.
Okay.
And Rosemary S. I can't read that.
Let me see.
S41F. S4K1F. Along with Farmer
I would
Whitehead,
say
who we mentioned.
Rosemary.
Rosemary, sorry. So what do they get, babe?
Oh, family hugs. Welcome. 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 We love our members so much.
Yes. Some guy with cancer. Oh, that's sad. I'm sorry.
Oh,
Um, Gull shouldn't be on the bench for any cases, including parking tickets. I'll also be trying to attend Aaron Spencer's hearings.
me
Good.
too.
Good.
I think I don't know there's going to be any hearings. I think I know that there's motions pending. I think that those will probably get ruled on the papers. I think it's trial, man. I mean, there could be, obviously there will be a final pretrial hearing wherein they'll deal with certain motions in limine. But in terms of kind of the motion to dismiss that's still out there and floating in the ether, I don't think that there's going to be argument. I think that both sides will stand on the papers. So we'll see. We'll see how
see.
that plays out. I
But
mean, that trial's coming quickly.
But
It's right after the
Percocent,
holidays.
member for 19 months, thanks for your continued support, makes a very good point
Yes, she
on my
does.
whole Frank's issue.
Yes,
Maybe
she
they won't
does.
care. She won't get a hearing. She offered Libredo a Frank's hearing.
Yeah,
Oh,
and if you guys don't remember, Libredo was one of the lawyers that was handpicked by Judge Gull to replace Baldwin and Rosie after she booted him off the case. Or, I'm sorry, after they withdrew from the case.
right. And he said, I agree with what they said.
Yeah, I mean, he's on public record in a media interview, I think on 2 media interviews, saying, yeah, when I first got the case, I was like, oh yeah, that's old shit. Like what a bunch of bullshit. What's a bunch of malarkey. And then he's like, and then I looked at the evidence and I'm like, oh my God. It's like I too, I actually believe that Rick Allen is factually innocent, which is this is a handpicked dude. And if you know anything about Allen County, where Gull sits on the bench, Libredo was the public defender in her courtroom. She knew him. Bill was specifically picked to handle this case. And I'll never forget the day that, and for the life of me, I can't remember what the other lawyer's name is. I'm sure somebody in the chat will know, but I'll never forget. It was the day after, the hearing set. It's going to be the first day that Libredo and the other dude are coming in, and they are made aware, okay, that Baldwin and Rosie have now entered their pro bono appearances on behalf of Rick Allen. So you have this incredibly weird situation wherein you've got the 2 attorneys that Gull has handpicked, okay, and now you've got the 2 other guys that Rick Allen wants to continue to have represent him, and they're all in the courtroom. All right. So you've got one counsel table for, the defense. And I can't remember if it was Brad or Andy was talking about this thing wherein they are where they're going to sit. And I can't remember if I think it was Brad. Brad's like, where's lawyers? We're sitting at counsel's table. So that's what they do. They sit at counsel's table. And so Libredo and other dude are behind them in the chairs that are set behind counsel table, but in the wall of the courtroom. So you got the bar, the little half wall. And so those 2 guys are behind them. And so when Gull comes onto the bench, right, she looks right over Baldwin and Rosie and directly addresses Libredo, because I'm sitting here thinking, before that hearing, I'm like, which guy is going to be lead counsel? Or are they not going to have lead counsel? So Gull answered that question for me, because she specifically addresses Libredo. And the first thing she says, oh, I assume, Mr. Libredo, that you are going to want to ask for a continuance of the trial. And he says, yes, Your Honor. And, so I knew right then and there that her handpicked guy was Libredo, and that scared the hell out of me. That scared the ever loving hell out of me. So, yeah, I mean, we'll see how this thing plays out. I'm very, very, very interested and anxious to get the appellate brief in our hands so that we can see what's what,
Right. All right. Thank the people.
All right. You guys are amazing. We love you so, so much. We'll be back tomorrow with something. We'll figure something out. So Babe, the Duran trial, which we abandoned, just completely abandoned, just left it. No warning. Just, you know what? Fuck that. We're not doing it anymore. We just let it. So that guy testified.
What?
Yes, which I thought that he was going to have to. Scremin, thank you, Richard Plunkett. Good man. You can always count on the chat here. But he testified, and I was reading some tweets that they were some people found him compelling.
Oh my
So did you
lord.
guys find him compelling? Like, let me know in the chat. All right. So in the interim, thank you guys all for your generosity, for those of you that made donos today. And as always, I'm going to give you the reminder, buried inside the John Wayne Gacy investigation, the podcast, audio only, is out there for you. There's the first 5 episodes. Episode 6 is dropping early morning before you wake up. So make sure that you have followed or subscribed wherever you get your pods. Make sure that thing's locked and loaded. It will automatically download for you if you do that, so that it's right in your feed as soon as you wake up. Because I'm telling you, 6 is where shit starts to get uncovered in terms of what we uncovered in that investigation. And another announcement that my brilliant, beautiful wife has made an executive decision. We have decided that we are going to start dropping 3 a week. So starting this week, we're going to have 6 on Tuesday. We're going to have 7 on Thursday. We're going to have 8 on Saturday. So we are going to be dropping 3 a week moving forward to get it out to y'all. So that's it. Mods, we love you. We thank you. We appreciate you. Tracy and Mandy, we love you. We appreciate you. To all of you members, we adore you. But to everyone who's here all the time supporting us, we are beyond appreciative of all of you. You guys have just formed an incredible community whom we love so, so very much. And because here's the bottom line, without y'all, I'm literally just an old man.
Sitting around talking to his wife.